We are back on MorningLine News Channel 5. Legal analyst Nick Leonardo is along with me here this morning. The number 737-7587. Questions about cases. The Michael Mosley triple stabbing case was set to go to trial today. It's been postponed until January 20th. High-profile case, awful situation where two young men lost their lives outside the Dogwood Bar a little bit before Christmas 2 years ago. We're talking about how this case is going to move forward. Mosley says it was self-defense. The prosecution say this is murder. The Rittenhouse case right now in Wisconsin. He took the stand in his own defense, and a lot of people were surprised at it. But you know what? As I watched the way he did, I didn't walk away from it saying he completely hurt himself, or frankly, that he completely helped himself. I think it was another piece of the puzzle, and I think most jurors would love to hear from the defendant, and they don't very rarely get to hear it. But what do you think, and you think there's any chance Mosley, similarly, could take the stand, like Rittenhouse, to explain why he acted the way he did, that he feared for his life?
You know, that was fascinating, I guess, to see the snippet of him testifying. And I think, you know, it appears as though a lot of folks I've heard say that the judge there appears to be on the defendant's side. But the prosecution, while he was testifying, had some inappropriate comments. They were asking him, well, why didn't you talk to the police back then? You didn't tell the police anything, you know, when this happened. And of course, that is trying to penalize him for remaining silent. Okay, you have the constitutional right to remain silent. That cannot be held against you. And so that's why I think, you know, the judge is clearly trying to give him a fair trial, okay? But I don't know that it helped or hurt. I do think one of the witnesses that got up there and was shot, it was an EMT or something, it was shot in the bicep. And he pulled a gun on Rittenhouse before Rittenhouse fired at him. And so it's, you know, maybe that count, there could be a discrepancy, but I mean, I think the pink elephant in the room is the fact that this kid comes with an assault rifle from another state, okay, down here trying to police things, and I think that that's going to backfire on him, and I think that he will be held. I'm hoping that he is held accountable for that. But the one takeaway that I had from that whole incident was when you see him standing there holding the assault rifle, and he put his hands up when the SWAT team passed by, and I think they gave him a water. And so if you don't think that we don't have a problem with policing in America, you're just not watching the same stuff I am.
Yeah. By the way, they could come back with lesser includeds, couldn't they? And that's what they say can make it more. It was interesting. Driving in this morning, I was listening to NPR, and they almost were laying it out. I've learned so much from you, and I think many of our viewers are educated that they've got a handle on what that is. But they actually had the reporter there on the Rittenhouse case explain to people what lesser includeds are, and it's one of the things that can make it more complicated for a jury, right? Where, you know, they don't just have to settle necessarily on the most serious charge. They could come back with something less for Rittenhouse.
Right, and it's got to be unanimous. All right, so they all have to agree on a verdict. And here in Tennessee, the jury doesn't know what the punishment is. Now, obviously, if you're facing first-degree murder, I think jurors know that's probably life in jail. Okay, but the lesser penalties, such as second-degree murder, manslaughter, reckless homicide, or criminally negligent homicide, the jury obviously knows that sounds a little less, you know, drastic of a charge, but they don't know what the punishments are that are associated with that. That's something that happens at a separate sentencing hearing after the jury renders a verdict. But they will be instructed on all the lesser applicable, lesser included offenses in that state.
Okay, so it could come back. We're not sure what they'll come back with. It may not be the most serious. Let's take a call from Ron. Ron, good morning. Hi, Ron.
Yeah, I got two questions for him, and then I'll hang up and listen to his answer.
Sure.
First question is, I want to know if he ever heard of the Cornbread Mafia that was on Dr. Phil, where the little girl up in East Tennessee disappeared, and Dr. Phil was asking if they thought maybe that Cornbread Mafia was involved in that. That goes back to 1980, and if you read Winnebago on the Cornbread Mafia, you'll see what I'm talking about. Also, I want to ask how it is that a cop that, a prison guard that is where Channel 5 did the story on the prison guard that punched the holes in the coffee cups, and they said do not rehire. How is it that a prison guard can go to police school, get certified as a policeman, go to Bedford County, get a job as a policeman in Bedford County, get fired or got rid of there, come to Marshall County, get involved with killing the man down there in Marshall County Jail, wind up in Mount Pleasant and still say that he's fixing to stay in police work. How is it that they can stay in that police work, and is it not really dangerous for the whole community and for everybody when they allow policemen like that to stay on the job?
You know, that was a story Ben Hall did, and you talked about how maybe there's problems with policing, and in my opinion, based on Ben's story, yes, that's an example of a problem. That dude should not be in law enforcement.
Yeah, you know, as far as the Cornbread Mafia, that's new to me. I haven't. I don't know if you've heard of the Cornbread Mafia.
No, I mean that's the first I had heard of it. It's the Summer Wells case out of far east Tennessee. The little girl's still missing, and the family had gone on the parents, Dr. Phil, last week, and I've seen snippets of it, and I was going to do some research and post something on it, but raising questions about maybe, all right, how do we explain where this girl went? You know, the parents have not been charged, you know, and there's no sign of the child, thinking as there is an abduction, and I'm not familiar as much with Cornbread Mafia. That's the first time I had heard of it either. Okay. But they're wondering if there's just a larger conspiracy involved here, you know, somehow a cover-up, or who is it that took the little girl if she was abducted.
All right, you know, I haven't heard anything about that, but as it pertains to police officers, that's kind of a good question there, Ron. What happens is that once you go to the police academy, you have to get post-certified or post-accreditation, okay, and that's what really vests you with the abilities to be a police officer in any particular locale. So, and after you get out of the academy, in order to get that accreditation, you have to ride along with a field training officer, I believe, for 6 months, and then you have this accreditation. Well, this accreditation a lot of times can travel with you. You can get fired. You know, people get fired in Metro all the time, but they don't lose their post-accreditation. Okay, once you lose that, you do not have the ability to be a police officer in America, and so and every department is different, and how they look at this post accreditation that these police officers get by going to essentially, you know, police school to learn how to do that, and so that accreditation continues to travel with them, and that's something that, you know, maybe you could look at overall in America, and maybe there could be some federal rules about this potentially that talk about, you know, if you're convicted of this or that, or how many infractions that you lose your post accreditation.
Are you supposed to? You have a certificate or a card you show if you're applying for a job, and they say, all right, do you have your accreditation?
You know, I don't know if it's that, or they can just go back and check, you know, obviously that you're you have your post accreditation.
Yeah, and you wonder if they do the checking, which is part of the problem. Some of these departments don't. They're so desperate to find officers sometimes. They take someone. It reminds me of, you know, doctors who maybe have lost their license to practice medicine in one state or one part of a state, and they move all the way across to the other state, and they're not aware of what happened elsewhere. And unless someone does some real digging, they just, wow, here's my credentials, and they get hired here. Same thing maybe with law enforcement. They have a problem somewhere else, but then they go and they come to a new area with a blank slate, and they bring that baggage no one knows about.
Well, and look no further than Jennifer Krause's story if you want to see about, you know, the one she did about the doctor with the COVID waivers, okay? I mean, obviously, you know, that's Tennessee should, the Board of Medical Examiners should do something, you know, or at least conduct an investigation into that sort of thing. And so it's the same thing with the police, you know, looking at whether or not those individuals should keep their post accreditation is something that, you know, they need to take a look at.
Yeah, that's a fair question, Ron. You wonder how many others are out there perhaps like him that taking time bombs one way or the other that could end up doing something. Should not be carrying a gun, should not be in law enforcement.
But with that said, you know, there's always outliers, and one seems to, you know, give a bad name to quite a few, but I think by and large we have a good police force here in Nashville by and large.
Yeah, so, you know, many of the cases, by the way, getting back to the one we were discussing with Michael Mosley, I mean, others, you know, be it the Joe Clyde Daniels case, going back to a lot, very, very, very rarely does a defendant take the stand in his own defense. Okay, we just don't see it very often. And in those cases we've done before, Nick, wouldn't you agree? There wasn't a question, be it the Vanderbilt rape trial or you know, Joe Clyde Daniels, of self-defense in this case. But as a juror in a self-defense case, meaning that's the defense for the guy who's charged, I would want to hear from the suspect to have him or her say, yeah, I was really scared, I was frightened, you know. Those are the one case where I'd expect you might hear from the defendant.
Well, especially if they don't have a prior criminal record. That's something that maybe they could be impeached with. But what you want to do as the defense attorney when you have an individual testify like that in their own behalf is that you want the jury to like them.
Yeah.
Okay, you want to humanize these individuals, and I think Rittenhouse was coached very well. Okay, I mean, and that's what you do as a defense attorney. You meet and you go over it. You cross-examine them to where they get up there, and it's kind of a cakewalk or a piece of cake for them because you have practiced this so much. But I think the goal a lot of times, not only do you want to hear from them in a self-defense context, but you want the jurors to like your client, okay? And so that's a big risk you take depending on the person that you have as your client and how good that prosecution is, and if he's got a prior criminal history.
Yeah, so there's always risk involved. So most of the time then, you've told me this before, if you're going to put the defendant on the stand, it's like a Hail Mary. It's at the end of the defense case, and you've kind of looked at everything like, you know what, the prosecution did, we're kind of in a pickle here. We're going to lose. Let's just put him on the stand.
Well, and there's a big, long jury charge that comes at the end of these criminal cases that have, instructions that the jury is supposed to use in considering guilt or innocence. And part of the instructions are given is that if the defendant doesn't testify, you're not to put any significance on that.
Right.
Okay? And that's not an inference of guilt. Again, the state has the burden of proof, and they have the burden of proof on each element of the crime beyond a reasonable doubt. So a lot of times, if your client doesn't testify, you say they didn't carry the burden. Why would we get up here and kind of bid against ourselves or try to prove a negative? You see, the state brought their best case today, and it's weak. And can you go home, lay your head down at night with certainty, okay, that you made the right decision? And I think a lot of times that's where you go, is to say they haven't carried the burden of proof.
All right, that burden of proof, self-defense. We'll take a break. When we come back, whether it's the Mosley case or any other one involving someone claiming self-defense in an action, I want Nick to kind of explain to me what the jurors will have to decide, whether or not, it is an actual case of self-defense or murder. That's what they're ultimately going to have to decide. We'll be back with more. We'll take more calls right after this.
This is a Storm 5 weather update. For weather on the go, download